The National Labor Relations Commission and its labor arbiters hold an important role in resolving labor disputes in the Philippines. They were created under the Labor Code of the Philippines, which sets the rules for their creation, powers, structure, and procedures. The NLRC is a quasi-judicial body tasked to promote and maintain industrial peace by resolving labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. It is attached to the Department of Labor and Employment for program and policy coordination. What is the jurisdiction of the NLRC? Original and exclusive jurisdiction of the NLRC. The NLRC has original and exclusive jurisdiction for the following cases. 1. Certified cases for compulsory arbitration in relation to Dole Secretary's assumption of jurisdiction. 2. Extraordinary remedies via a verified petition to annul or modify the order or resolution of the labor arbiter. 3. Petition for injunction in labor cases, and for contempt cases. Exclusive appellate jurisdiction of the NLRC. The NLRC has exclusive appellate jurisdiction for the following cases. 1. Cases on monetary claims resolved/decided by the Dole Regional Director, except those arising from the visitorial and enforcement powers of the Dole Secretary. 2. Cases decided by the labor arbiter. 3. Third-party claim. A third party may file a third-party claim with the sheriff of the labor arbiter, and if the third-party claim is denied, the third party may appeal the denial to the NLRC. To perfect an NLRC appeal, the following must be complied. 1. The memorandum of appeal must be filed within 10 days from receipt of the decision, award, or order by the labor arbiter, or within 5 days from receipt of the decisions or resolutions by the Dole Regional Director. 2. The appeal must be verified by the appellant. 3. The format of the memorandum of appeal should state the following: A. Grounds. B. Arguments. C. Relief prayed for. D. Date of receipt of appealed decision, award, or order. 4. The appeal should be prepared in 3 legible typewritten or printed copies. 5. Proof of payment of appeal fee and legal research fee. 6. Posting of a cash or surety bond, if applicable for employers. And 7. Proof of service upon the other parties. Grounds for appeal. The following are the grounds for appeal. 1. If there is a prima facie evidence of abuse of discretion on the part of the labor arbiter or regional director. 2. If the decision, award, or order was secured through fraud or coercion, including graft and corruption. 3. If made purely on questions of law, and/or. 4. If serious errors in the findings of facts are raised which, if not corrected, would cause grave or irreparable damage or injury to the appellant. Venue. The appeal shall be filed with the Regional Arbitration Branch or Regional Office where the case was heard and decided. Bond. If the employer appeals a labor arbiter's decision which requires payment of monetary claims, a bond shall be required to be paid on or before the filing of the appeal. An appeal by the employee does not generally require a bond. General rule: no motion to reduce bond allowed. In case the decision of the labor arbiter or the regional director involves a monetary award, an appeal by the employer may be perfected only upon the posting of a bond, which shall either be in the form of cash deposit or surety bond in an amount equivalent to the monetary award, exclusive of damages and attorney's fees. No motion to reduce bond shall be entertained except on meritorious grounds, and only upon the posting of a bond in a reasonable amount in relation to the monetary award. Exceptions: when reducing bond is allowed. The mere filing of a motion to reduce bond without complying with the requisites in the preceding paragraphs shall not stop the running of the period to perfect an appeal. The filing of a motion to reduce appeal bond shall be entertained by the NLRC subject to the following conditions. 1. There is meritorious ground. And 2. A bond in a reasonable amount is posted. For purposes of compliance with condition number 2, a motion shall be accompanied by the posting of a provisional cash or surety bond equivalent to 10% of the monetary award subject of the appeal, exclusive of damages and attorney's fees. Compliance with the foregoing conditions shall suffice to suspend the running of the 10-day reglementary period to perfect an appeal from the labor arbiter's decision to the NLRC. The NLRC retains its authority and duty to resolve the motion to reduce bond and determine the final amount of bond that shall be posted by the appellant, still in accordance with the standards of meritorious grounds and reasonable amount. In the event that the NLRC denies the motion to reduce bond, or requires a bond that exceeds the amount of the provisional bond, the appellant shall be given a fresh period of 10 days from notice of the NLRC order, within which to perfect the appeal by posting the required appeal bond. In conformity with the NLRC rules, the monetary award, for the purpose of computing the necessary appeal bond, shall exclude damages and attorney's fees. Only after the posting of a bond in the required percentage shall an appellant's period to perfect an appeal under the NLRC rules be deemed suspended. Effects of perfecting an NLRC appeal. Without prejudice to immediate reinstatement pending appeal, once an appeal is filed, the labor arbiter loses jurisdiction over the case. All pleadings and motions pertaining to the appealed case shall thereafter be addressed to and filed with the NLRC. The perfection of an appeal stays the execution of the decision of the labor arbiter, except execution for reinstatement pending appeal. Injunction. Section 1. Injunction in ordinary labor disputes. A preliminary injunction or restraining order may be granted by the Commission through its divisions pursuant to the provisions of paragraph E of Article 225 of the Labor Code, as amended, when it is established on the basis of the sworn allegations in the petition that the acts complained of involving or arising from any labor dispute before the Commission, which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party. A certification of non-forum shopping shall accompany the petition for injunction. The writ of preliminary injunction or temporary restraining order shall become effective only upon posting of the required cash bond in the amount to be determined by the Commission to answer for any damage that may be suffered by the party enjoined, if it is finally determined that the petitioner is not entitled thereto. The Commission shall have the power and authority to enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in any labor dispute which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party, provided that no temporary or permanent injunction in any case involving or growing out of a labor dispute as defined in this code shall be issued except after hearing the testimony of witnesses, with opportunity for cross-examination, in support of the allegations of a complaint made under oath, and testimony in opposition thereto, if offered, and only after a finding of fact by the Commission, to the effect 1. That prohibited or unlawful acts have been threatened and will be committed unless restrained, or have been committed and will be continued unless restrained, but no injunction or temporary restraining order shall be issued on account of any threat, prohibited or unlawful act, except against the person or persons, association or organization making the threat or committing the prohibited or unlawful act, or actually authorizing or ratifying the same after actual knowledge thereof. 2. That substantial and irreparable injury to complainant's property will follow. 3. That as to each item of relief to be granted, greater injury will be inflicted upon complainant by the denial of relief than will be inflicted upon defendants by the granting of relief. 4. That complainant has no adequate remedy at law, and 5. That the public officers charged with the duty to protect complainant's property are unable or unwilling to furnish adequate protection. Motion for reconsideration. Section 15. Motions for reconsideration. Motion for reconsideration of any decision, resolution, or order of the Commission shall not be entertained except when based on palpable or patent errors, provided that the motion is filed within 10 calendar days from receipt of decision, resolution, or order, with proof of service that a copy of the same has been furnished within the reglementary period, the adverse party, and provided further that only one such motion from the same party shall be entertained. No appeal from decisions, orders, or awards of the NLRC. There is no appeal from NLRC to the Court of Appeals or Supreme Court. After the lapse of the 10-day period to file a motion for reconsideration, the decisions, orders, or awards of the NLRC become final and executory and therefore unappealable. The only mode by which a labor case decided by the NLRC may reach the Court of Appeals is through a Rule 65 petition for certiorari. The NLRC is not bound by the technical rules of evidence and procedure observed in regular courts, though it must still observe due process and fair play. Decisions of the NLRC, while final and executory after the lapse of the period for appeal, can be reviewed by the Court of Appeals via a Rule 65 petition and ultimately by the Supreme Court on questions of jurisdiction or grave abuse of discretion.